So family sends their kid in Vaughan to a daycare center. That kid apparently had tested positive for COVID or was positive for COVID. And while we're not being told by officials what the name of the child care center is, CP24 thinks they dug it out. They say there is an outbreak involving 15 children at Tiny Treasures Learning and Child Care Center Incorporated. What happened to the parents is $770 fine and a victim surcharge fee totaling $880. So were the parents here treated appropriately, inappropriately? How should these things progress? To try and forward the discussion, Nainesh Kotak, Kotak Personal Injury Law, joins me now. Good morning.
Good morning, Jerry. Thanks for having me.
Was this a reasonable charge against these parents, do you think?
I think it's an expected charge. We don't know the full circumstances if this child had actually been tested or, what those symptoms are. But, there is jurisdiction here. We have what's called the Health Protection and Promotion Act. And this act permits medical officers or regional medical officers to give directives or orders requiring that certain actions take place. So in this particular case in York region, there was an order that, if you have symptoms of COVID or if you have tested, that there's an isolation period of 10 days. And we also know that, the schools have a requirement and even daycares to go through that screening process. So obviously, a correct process wasn't followed here. Of course, we don't know if it was was it a sniffle or what have you. Not information has come out, but there certainly is jurisdiction to do this. We know the unfortunate outcome was 15 children were exposed and actually became infected with COVID-19. And what does that mean? They have to be home. Their parents could get it, right? So obviously, there's consequences. Section 23 of that same act does require, in fact, caregivers or parents to ensure that there's a compliance by minors. In this case, obviously, we're dealing with a toddler. So there's jurisdiction. Is it overhanded? Keep in mind, this is not a criminal charge, right? It's a provincial offense. Essentially, it's like getting a speeding ticket in terms of you don't have a criminal record. You can still travel, these types of things. So it's in some sense it's a bit of a slap on the wrist. It's akin to getting pulled over and having a speeding ticket. Maybe there's some embarrassment, but they're not publishing the parents' names. I don't think they would do that. They tend to publish more the corporation instead of if it was a school who was at fault, they'd probably publish that as opposed to a parent's name.
Nainesh Kotak is with me, Kotak Personal Injury Law. Vaughan parents charged after allegedly sending a child with COVID-19 symptoms to a daycare. But if you're going to find somebody, you're going to levy some kind of penalty that totaled $880, Nainesh. I think you'd have to demonstrate that they knowingly sent a sick kid.
Yeah, I think, unless it's a strict onus, a strict liability offense, which it doesn't appear to be so, at least from my view of the legislation, there'd have to be some knowledge. But then, therefore, the knowledge doesn't have to be that, I knew my child had COVID-19. It may well be, symptoms of. That's what the directives talk about, right? So whether or not they'll be found responsible at the end of the day to pay a fine, it's unclear. Where people have to watch out for potentially is also civil liability. There is a fair bit of protection under what's called Bill 218, which really came about to sort of protect long-term care homes. But it has the overriding effect of protecting any person, which includes, parents and individuals, from civil liability if COVID is spread through their actions, unless it can be shown that they didn't act in good faith, which means basically didn't act with an honest belief. So potential civil liability, although the legislation tends to protect people in order that the economy can open up.
Well, I think it's very difficult sometimes to know, because just to give a personal example, Nainesh, my wife was in Pittsburgh and was going to come back here, went in to get the COVID test to demonstrate a negative test in order to cross the border, and she failed the test. She felt fine. Yeah,
this is the thing about this disease, right? Some of the tests, how's the accuracy for some of the rapid screening, right? There's obviously sometimes questions with that.
Well, my wife didn't get rapid testing. She got the
regular.
Yes.
There's a lot of asymptomatic carriers, right? And that was one of the issues why the pandemic still is around, because when it came to the initial SARS, right, 2003, the symptoms were so profound that you have it and you get, the symptoms hit you right away. You stay home and we're able to control that pandemic. Here, some people just, fortunately for them, but, they have many very minor symptoms or not at all, and which if they go about their daily business without knowing, then obviously then a spread could occur.
I'm talking to Nainesh Kotak, Kotak Personal Injury Law, about this Vaughan family that was charged after allegedly sending a child with COVID-19 symptoms to daycare. Now, I found the one line in the CP24 report a little confusing, so I may misunderstand this. The line is the parent was subsequently charged $770 and a victim charge fee totaling $880. Does that mean $880 was the total paid, or $880 victim surcharge fees plus the $770 fine?
It appears to be a total of $880. And again, this is just a charge. I don't think there's evidence that they pled guilty to it or that they paid a fine. There are some options, if you're charged with a provincial offense, including this one. One would be to simply to fight it if you think you're not guilty and have a trial. The other is to have a resolution meeting with the provincial crown and have a discussion, which sometimes they can get withdrawn or other outcomes. So it doesn't mean that they're guilty just because they were charged.
All right. And so some people are writing into me saying that any of the parents of the kids who got sick, perhaps as a result, should sue this family. Would that fly in court?
Yeah, under normal circumstances, perhaps, but with Bill 218, which again was introduced to sort of protect long-term care homes, it has overriding protections for anybody who has caused the spread of COVID. Those parents would have to show that the offending parent, in this case, actually did not act in good faith to comply with public health guidelines, or that they were grossly negligent, which means that they were, there's a sort of a marked departure, really recklessness. So the burden of proof is much stronger and more difficult to meet than it would be under ordinary circumstances because of the legislation that came into force at the end of last year.
Are we going to see a lot of legal action, do you think, going forward out of COVID? All kinds of people taking action about getting back to work, taking action against other people because they say they gave me COVID. Is it going to be sort of a run on the courts?
Well, I think where you see some litigation already is employment situations where people have been let go or where they still want to be accommodated from home and the employer, doesn't have to do that. So I think you're going to see litigation there. Certainly, with my office, we have many disability claims that are due to long COVID, where the impact of the symptoms are lasting beyond 12 weeks. So I think you're going to see it there. There's already business interruption insurance litigation going on. That is where a place of business had to close down. They weren't an essential business, and they've lost income, and they've had insurance. And insurance companies are saying, well, this, you're not covered under your business interruption. So there's already litigation going on there. Family law proceedings, custody and access proceedings with different views as to whether children should go in class or not in class. And, so you've already seen that. So there already is a fair bit, and I think it will continue. And certainly, in terms of mental health, claims for disability, et cetera, this is going to be with us for quite some time because obviously the pandemic has taken its toll on various segments of the population.
All right. So what can parents, daycare operators, schools, what can they do to reduce liability if people are going to get sued like this?
Well, there are things they can do, and they're set out very clearly in directives from the various regions. Obviously, have the screening. Children, grade 1 and under, don't have to wear masks unless it's ordered to do so or absolutely necessary. I've got my little one; she's 4 years old, goes to Montessori. We've had her home for 2 days, little sniffle, right? But I don't want to take a chance in case she has something passed on to other kids. So she's been home second day running around, right? So parents will be a little cautious, obviously, and schools, obviously they have to take the screening very seriously. Should be done online every single day, no day exception, and parents need to take that very seriously as well and complete it accurately every single day. What you do find is there's no entry for parents. The kids just sort of get let off, and the parents, when they come to pick up, should be wearing masks. So I think, as long as they're complying and doing their best to, in good faith, to comply with public health guidelines, I think they'll be protected from liability.
Nainesh Kotak, Kotak Personal Injury Law. Great to have you. Thanks very much for this.
Thanks so much, Jerry. Take care.